under the Constitution. I'll say it over. Welcome to our religious liberty under the Constitution, according to the Supreme Court. We'll be meeting today and March 23rd, April 27th, and May 25th. Since May 25th is Memorial Day weekend, I hope we have plenty of people here, but if we don't, it's still going to be on Zoom and also on YouTube. I'm sure it's still on there, but you're seeing everything else I'm doing. I don't know how to stop that. Yeah, you're going to end up seeing all my notes, but fortunately it's far enough away from here that you won't be. Say that again? Okay, just a minute. All right, so let's start out with the fact that this does emphasize the Constitution, this lecture series. So, can anyone tell me anywhere in the Constitution as ratified originally that there is anything about religion mentioned? Anything at all? I mean, we can't really count in the year of our Lord 1788 or 87 or what. In this case, I think it was 87 for the writing, because that was the only calendar in existence. So they weren't expressing a belief that Jesus was their Lord. They were just telling you what the year was. So there is no place in the original Constitution where religion is mentioned except for one. In Article 6, on the supreme law of the land, the third clause about oath of office says, the senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. But no religious test shall ever be required as a qualification to any office or public trust under the United States. So that's been true since 1787 at the Constitutional Convention. And what I've just gone over, seeing someone else come in, is actually on the screen if you're able to read it. So why did we end up needing a First Amendment? I mean, first of all, if there's no religion mentioned anywhere in the Constitution, then how would the federal government have the authority to interfere with it? Or set up a national church? Or in any other way affect religious liberty? Freedom of religion, in fact, had a long history in colonial America. Baptist Roger Williams founded the state, at the time, colony of Rhode Island and Providence Plantations. Congregationalist Thomas Hooker founded Connecticut. Fortunately, he named it after the river, named after the Indian tribe, and so we don't currently have a state of Hooker. And Quaker William Penn founded the Commonwealth of Pennsylvania and New Jersey, which was originally part of the same state as eventually was Delaware for a while. And all three instituted religious freedom for all inhabitants except atheists. It was believed that you had to believe in some God, some way, somewhere to be a decent person. So they exempted atheists from that. And in fact, the constitutions of some of the states specify that no atheist shall hold public office or may not have the right to vote or serve on juries because they can't take the oath to God to serve. In direct reaction, what these three men did, in direct reaction and opposition, was to the established religions that persecuted dissenters in, for example, the Massachusetts Bay Colony, where separatist Congregationalists we call the Pilgrims, and Plymouth Colony, which they founded, as well as throughout both before they were united into one colony, under the Puritans, persecuted anyone who wasn't a Pilgrim and then later who wasn't a Puritan, and expelled Anabaptists and Quakers. You had the choice. You could be, I forget if it was beheaded or drowned, but you had the option at your own choice if you'd just like to be banished. I think most people picked that one. Lord Baltimore established Maryland as a Catholic haven, the only place in the New World outside of Quebec that Catholics could have freedom of religion at the time that he established it. Of course, as I said earlier, Roger Williams, Thomas Hooker, and William Penn ensured that their own colonies had religious freedom. So Catholics were safe there if they chose to live there. Anyway, the point is that eventually Protestants in Maryland passed laws to restrict Catholicism. We must stop the progression of papism in our colony. And they exerted control over Catholicism, and thus religious freedom and persecution went back and forth for decades in Maryland. Most of the rest of the colonies either established the Anglican Church, the Church of England, or Congregationalism, the forerunners of the Unitarian Universalists and the United Church of Christ, as their official tax-supported religions. But these were eventually disestablished under pressure from persecuted Baptists and Presbyterians, and eventually their Methodist allies. The most prominent case of this was the Virginia Statute for Religious Freedom, written by Thomas Jefferson, passed in 1786. It established freedom of conscience and belief in the Commonwealth of Virginia, as well as explicit separation of church and state. Jefferson was so proud of it that it is one of only 3 things he wanted to be remembered for, and had them placed in his will on his gravestone, along with being the author of the Declaration of Independence and founding the University of Virginia. Once again, you have the little bits on the side, but here is a close-up of Thomas Jefferson's gravestone. Here was buried Thomas Jefferson, author of the Declaration of American Independence, of the Statute of Virginia for Religious Freedom, and father of the University of Virginia. He didn't care about his time as a diplomat, and he didn't care about his time as president. He just wanted to be known for those 3 accomplishments. Although the last vestige of state religions did not end until 1833, as a practical matter, every one of the former colonies had separated church and state by 1820. Now, keep in mind, the First Amendment was passed and added to the Constitution in 1791. That gives you a little hint about some other things we're going to get to later. But again, church and state were separated by 1820 in the former colonies, and no new states admitted to the Union after the original colonies had their own state churches. One of the reasons that we got the First Amendment was the Federalist Papers. These were 85 articles and essays published under the pen name Publius, written by Alexander Hamilton, John Jay, and James Madison to promote the ratification of the Constitution against their opponents, the Anti-Federalists. Hamilton, of Broadway fame, was a delegate to the Constitutional Convention, became the first Secretary of the Treasury, and was later killed by Vice President Aaron Burr in a pistol duel. Jay, the second governor of New York State, became the first Chief Justice of the Supreme Court. And Madison was elected fourth President of the United States, serving after Thomas Jefferson. The Federalist Papers argued that no religious test would be necessary because the people could be trusted to choose the best candidates for office regardless of faith. And so they gave in to anti-Federalist arguments and public pressure in order to get the votes they needed for ratification by making sure that the no religion test was included in the Constitution. Anti-Federalists argued that the strong new federal government was dangerous to liberty and needed to be reined in. Federalists responded that the federal government had no power but what the Constitution specifically authorized. Since the Constitution nowhere mentioned religion, other than prohibited religious tests for office, the United States could not establish any or interfere with its practice. Nevertheless, the Federalists eventually gave in to call for a Bill of Rights to be added to the Constitution, again to gain the votes needed for ratification. The Bill of Rights consisted of 12 articles of amendment submitted for ratification by the states. 10 passed together and took effect in 1791. One still has not passed, and the last of them was ratified by the requisite number of states and took effect in 1992, the 27th Amendment. It waited about 201 years to complete ratification. So, what does the First Amendment say? Those of you with really good vision or binoculars can see what's currently showing on your screen, but I'm going to read it anyway. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press or the right of the people peaceably to assemble and to petition the government for a redress of grievances. Can anyone explain or guess why it says Congress shall make no law respecting an establishment of religion? It doesn't say the, or it doesn't omit the articles entirely. It says an establishment of religion. Anyone know why? No? The Constitution, if it were to respect the establishment of religion, would mean that the federal government could, in fact, recognize state churches. But respecting an establishment of religion means that the federal government cannot establish its own religion, and it cannot interfere with any of the state churches. So if the official state church of New York was the Anglican Episcopal Church, Congress can't interfere. Yes, this is 1791, and it wasn't until 1820 in practice and 1833 on paper that the last state church was disestablished. Only the original colonies, and only those that were not freedom of religion from the beginning, still had their own state churches at this point. Virginia had passed its statute for religious freedom, so it had disestablished the Anglican Church. And the Carolinas and Georgia, I believe, still had the Anglican Church, what we now call Episcopalian, as the tax-supported church of the state. The Congregationalists were in charge in Massachusetts. So there were several states that had their own churches, which did not necessarily require every member of the state belong, but did require that every member of the state pay taxes to support. So your local church was supported by your local and state taxes, whether you went to it or not. Maybe you were a dissenter, you were a Quaker, meeting in a root cellar somewhere to avoid persecution. You still had to pay to support the Congregationalist church. You might have been a Methodist in the South, but you still had to pay taxes for the Church of England, as separated now in America to constitute the Episcopal Church. The money didn't end up in England anymore, but it ended up in the same denomination. So Congress shall make no law respecting an establishment of religion means Congress could not interfere in any way for or against a state church in the United States. States were free to have whatever religion they wanted, and Congress could neither support it or oppose it. And Congress shall make no law prohibiting the free exercise thereof. So this left the freedom of religion in the United States up to the states and to the people, depending on how it worked in a given state. The state may have left it up entirely to the people, or it may have had its own tax-supported church. The Constitution nowhere says who has the right to interpret and apply it. We take for granted today that that is the duty of the judiciary branch, especially the US Supreme Court. But that is not found in the Constitution anywhere. Search every word of the Constitution, and you will not find the power of judicial review. But it was taken for granted by the Federalists when the Constitution was being ratified. In Federalist number 78, Alexander Hamilton wrote, "If it is said that the legislative body is themselves the constitutional judges of their own powers, and that the construction they put upon them is conclusive upon the other departments, it may be answered that this cannot be the natural presumption, where it is not to be collected from any particular provision in the Constitution. It is not otherwise to be supposed that the Constitution could intend to enable the representatives of the people to substitute their will for that of their constituents. It is far more rational to suppose that the courts were designed to be an intermediate body between the people and the legislature in order, among other things, to keep the latter within the limits assigned to their authority. And also, the executive not only dispenses the honors, but holds the sword of the community. The legislature not only commands the purse, but prescribes the rules by which the duties and rights of every citizen are to be regulated. The judiciary, on the contrary, has no influence over either the sword or the purse, no direction either of the strength of or the wealth of the society, and can take no active resolution whatever. It may truly be said to have neither force nor will, but merely judgment, and must ultimately depend upon the aid of the executive arm, even for the efficacy of its judgments. The interpretation of the laws is the proper and peculiar province of the courts. A constitution is, in fact, and must be regarded by the judges as a fundamental law. It therefore belongs to them to ascertain its meaning, as well as the meaning of any particular act proceeding from the legislative body. But in the Anti-Federalist Papers, the opponent of ratification, calling himself Brutus, warned there is no power above them to control any of their decisions. There is no authority that can remove them, and they cannot be controlled by the laws of the legislature. In short, they are independent of the people, of the legislature, and of every power under heaven, men placed in this situation will generally soon feel independent of heaven itself. I do want to point out, though, like a certain current regime, the favorite president of whom, Andrew Jackson, once is reputed to have said, "The Chief Justice has made his decision, now let him enforce it." And then, ignoring the Supreme Court, Jackson confiscated the plantations and farms of the Cherokee Nation and marched them on foot to the deaths of many to Oklahoma on the Trail of Tears, in direct violation of treaties made with the Cherokee, which according to the Constitution, thereby constituted the supreme law of the land. Every so-called Indian treaty is considered of equal force as the Constitution itself. Ultimately, in Marbury v. Madison in 1803, the Federalists won their point. Marbury v. Madison was a landmark Supreme Court case where the court established the power of judicial review, meaning that the judiciary can declare acts of Congress unconstitutional, effectively setting a precedent for the courts to interpret the Constitution and check the power of other branches of government. This occurred when William Marbury sued James Madison for refusing to deliver his commission as a justice of the peace, appointed by President John Adams during his last days in office. And the court ultimately ruled that the law allowing Marbury to sue was unconstitutional, solidifying the Supreme Court's rule in interpreting the Constitution. President John Adams, shortly before leaving office, appointed several Federalist judges, including William Marbury. But the commissions were not delivered by the new Secretary of State, James Madison, under President Thomas Jefferson. So the issue is Marbury sued Madison, asking the Supreme Court to issue a writ of mandamus that forced him to deliver the commission. It was legally issued, and it was Madison's duty under the law to provide it to him, even though it was the previous president who issued them. Chief Justice John Marshall ruled that while Marbury was entitled to his commission, the court could not issue the writ because the law authorizing it conflicted with the Constitution, establishing the power of judicial review. This decision sets our stage for the US Supreme Court to decide ultimately what the First Amendment means, how far it goes, how it is to be applied, and to determine the boundaries and limits of the separation of church and state. Now note, it was 1789 when the Supreme Court basically took office, and it wasn't until 1803 that it decided for itself that it was the branch in charge of determining what the Constitution says. Now we're going to look at a relatively minor but ultimately important case precedent from 1833. John Barron, a wharf owner in Baltimore, sued the city claiming that construction projects diverted sediment into the harbor, making his wharf unusable and essentially taking his property without just compensation, violating his Fifth Amendment rights. That was called the Takings Clause. It says basically, eminent domain can exist, but if the state seizes your property, it must pay you for it, and it has to be a fair value. Barron initially won in the lower court, but then the Maryland Court of Appeals overturned the decision. The Supreme Court upheld the Maryland court's decision, stating that the Fifth Amendment only restricts the federal government and does not apply to state actions like those taken by the city of Baltimore. Baltimore was a political subdivision of the state of Maryland. The federal government had nothing to do with it. In Barron v. Baltimore, the Supreme Court ruled that the Bill of Rights, including the Fifth Amendment's Takings Clause, only applies to the federal government and not to state governments, meaning a citizen could not sue a city like Baltimore for taking their property without just compensation under the federal Constitution, as the city's actions were entirely a state matter. This case solidified the concept of federalism, where the federal government's powers are distinct from those of the states. Next, a case in 1845. We're getting closer to the present. A New Orleans ordinance prohibited holding Catholic funerals in churches with the deceased present, and Father Promoli was fined for violating this rule. Promoli argued that the ordinance violated his religious freedom under the First Amendment. The Supreme Court ruled against Promoli, stating that the Bill of Rights did not apply to state laws, meaning the New Orleans ordinance was not subject to federal constitutional review. Promoli v. New Orleans was a landmark Supreme Court case in 1845, where a New Orleans ordinance prohibiting Catholic funerals from being held in churches with a present corpse was challenged, and the court ultimately ruling that the Constitution did not protect religious liberties at the state level, meaning the ordinance against Father Promoli, a Catholic priest, was upheld, effectively limiting the First Amendment's free exercise clause to federal actions only. This case demonstrated the early limitations of the free exercise clause, showing that the Supreme Court at the time did not consider religious liberty protections to extend to state laws. Think about this. What does the First Amendment say? Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. It doesn't say a thing about states. States could do what they want. The Bill of Rights doesn't touch them. Those are restrictions on what the federal government can do, and what rights the people have the federal government can't interfere with or abridge. And it even specifies near the end that anything not specifically mentioned in the Constitution as a right of the federal government remains a right that belongs to the states or to the people. Basically, you can't assume any right belongs to the federal government unless it's laid out in the Constitution. So, at least up to 1845, if the state of New York did anything to infringe your religious activities, you couldn't go to federal court for it because there was no federal provision for protecting you from the state, only from itself. By the way, I did forget to do this earlier because of the odd way that my computer is being worked this time. So, a little out of order, but I did want you to see the picture of Alexander Hamilton, the chief author of the Federalist Papers, and the duel victim on the back of your $10 bills. In fact, he's the only victim of a duel on any US money. All right, so the Supreme Court did not address the First Amendment's religion clauses again until Reynolds versus United States in 1878. The facts of the case were thus: George Reynolds, a member of the Church of Jesus Christ of Latter-day Saints, the Mormons, was charged with bigamy under the Federal Morrill Anti-Bigamy Act after marrying a woman while still married to his previous wife. Reynolds argued that the law was unconstitutional. He reasoned that his religion required him to marry multiple women, and the law therefore violated his First Amendment right to free exercise of religion. In 1876, the Supreme Court of the Territory of Utah convicted George Reynolds of bigamy. Reynolds appealed to the US Supreme Court. The question under consideration is religious duty or belief a defense to a criminal charge? The court upheld Reynolds' conviction and Congress's power to prohibit polygamy. The court held that while Congress could not outlaw belief in the correctness of polygamy, it could outlaw the practice of it. The majority reasoned that while marriage is a sacred obligation, it is nevertheless usually regulated by law in most civilized nations. Chief Justice Morrison Waite wrote, "Polygamy has always been odious among the northern and western nations of Europe." Finally, the court held that people cannot avoid a law due to their religion. Reynolds' conviction was therefore upheld by a unanimous vote and remains standing case law to this day. A few years later, in 1890, after Congress had passed the Edmunds Act of 1882, which made polygamy a felony, over 1,300 Mormons were imprisoned. The act also required test oaths, requiring voters to swear they were not bigamists or polygamists. A statute of the Idaho Territory required a similar oath in order to register to vote, in order to limit or eliminate Mormons' participation in government and their control of local schools. The loyalty oath also forbade being a member of any organization that advocated or spent resources defending bigamy or polygamy. Mormons initiated a challenge to Idaho's oath test by having members who did not have plural marriages registering to vote. Samuel D. Davis, a resident of Oneida County, Idaho, was convicted in the Territorial District Court of swearing falsely after taking the voter's oath. By the way, I am not sure if that should be pronounced Oneida County, as I assume the same county in New York is pronounced, or if it should be Oneida County, as Jodie Foster pronounced it in The Silence of the Lambs. She may have been wrong, I may be right, I'm not sure. Davis appealed his conviction via a writ of habeas corpus, which is Latin for release the body, claiming that the Idaho law requiring the oath violated his right to the free exercise of his religion as a member of the LDS Church. Justice Stephen Johnson Field, writing for the court, condemned polygamy, writing that few crimes are more pernicious to the best interests of society and receive more general or more deserved punishment. He went on to echo Reynolds versus United States, 1878. However free the exercise of religion may be, it must be subordinate to the criminal laws of the country, passed with reference to actions regarded by general consent as properly the subjects of punitive legislation. He wrote by way of comparison that if a religious sect advocated fornication or human sacrifice, swift punishment would follow the carrying into effect of its doctrines, and no heed would be given to the pretense that, as religious beliefs, their supporters could be protected in their exercise by the Constitution of the United States. Following decades of federal efforts to end the practice of polygamy by members of the Church of Jesus Christ of Latter-day Saints, the Davis v. Beeson decision may have been a significant consideration, which helped convince LDS prophet and president Wilford Woodruff that the time had come to stop sanctioning additional plural marriages, as announced in his manifesto of September 1890, following the renunciation by the Church of Jesus Christ of Latter-day Saints of the everlasting covenant of plural marriage. The last impediment to Utah statehood was listed, and Congress admitted Utah into the Union on January 4th, 1896. Included in its constitution, approved by Congress, was a constitutional ban on polygamy. Scholar Richard Morgan wrote, "The Davis decision became one of the principal underpinnings of what later came to be called the secular regulation approach to the free exercise clause, whereby no religious exemptions are required from otherwise valid secular regulations." The secular regulation rule will come up again, I assure you. In terms of religious liberty, these polygamy decisions are appalling and extreme. In terms of feminism, they must be applauded for their rather unintentional rejection of the patriarchy. Of course, the court was all in favor of patriarchy, but found polygamy repulsive. This ends today's lecture. The second lecture will focus on the 20th century. And to give you a tiny little preview, the first case we'll discuss next time is Pierce versus the Society of Sisters from 1925, when the state of Oregon passed a law with the full backing of the Ku Klux Klan and the KKK members of the state legislature to make it illegal for any church to operate a school in the state. So that's our first for next time. And thank you for coming today. Do you have any questions? Thank you. I'm going to give you one last picture to send you off. That is true, yeah. It's hard when you're up here to think of everything, because, yes. So anyway, there you see a polygamist family of Mormons from that time. See you next time.